and what I expect to be a long line of lawsuits filed against government executives and agencies, the people that have instituted so many of these draconian, unconstitutional, illegal, and damaging orders, I found an interesting case out of the state of Michigan. So we'll talk about that next on the Constitution Study.
There's one thing you have to know wherever you make your stand. Came from a long through line of everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution, and we teach the rising generation to be free. Hopefully you noticed I got the first of my new shirts in. That's right, you can get Constitution Study labeled shirts available on the store. Go to constitutionstudy.com. Hit the shop button and you'll find more. I'm working on some more. I'd love your ideas. I'm trying to work out a whole series of shirts based on sayings of our founding fathers. So let me know if you have some ideas. I'd love to see if I can make them happen. As always, head over to that website. That is where you can find everything I'm working on. I'm going to ask you to do a couple things. I'm going to ask you, if you would please, click the sign up for the newsletter. It is the best way for me to keep in touch with you with what is going on in these crazy times we're living through. More and more of the Facebook pages I'm involved with, I'm seeing them having content blocked or at least put behind a wall because of fake news. These fact checkers, which seem to sometimes pay very little attention to facts. So if you want to know what's going on at the Constitution, sign up for the newsletter. And do me a favor, there's a checkbox when you do that that says send me your content. And I will email you, as soon as these videos come out, I will email you a link directly to the page and you can watch the video. We don't have to worry about Facebook shadow banning me. We don't have to worry about YouTube hiding the channel. This goes directly to you, and it avoids the possibility of some of these tech companies getting in the way. Now, I'm very glad you could join me today. I do want to remind you, I do have a webinar coming up later this month. That's right, I'm talking about the presidential election and the Electoral College. Now, I'm sure you are tired of hearing about the election, but there's some really important information. If you want to understand some of the nonsense that's been going on and what really should happen, sign up, go to constitutionstudy.com/elections. And sign up for the webinar. If you can't attend live, sign up anyway. I will send you a link to the recording once it is done and edited and posted on the site. So that would be a great way to find out how we actually elect a president, what the Electoral College is actually about, why we have one. I'll even answer some questions, including questions from you about things like, will Nancy Pelosi be president in January? Or what happens if a state has a problem with their elections and they don't get their votes in time? We'll discuss all that on the 24th, so please sign up and let me know. Right now, signups are really low, and I'm wondering why. I'm hoping it's just people are really tired of the election news and just want to get away from it, but there's some really good information there. So with that, let's talk a little bit about what's going on in Michigan. As I've said before, I'm skeptical of the idea of going to the courts, which are, by definition, government entities themselves, in order to receive justice from another government entity. So I believe there is a natural tendency for those who receive a government paycheck to lean towards supporting the position of the government. Now, that said, when I read the syllabus for this opinion, I found not only an example of a court opining based on the law, but several interesting points that I think are worth reviewing here. Now, from the case syllabus, we read, plaintiffs in the underlying federal case are healthcare providers that were prohibited from performing non-essential procedures while EO 2020-17 was in effect, and a patient who was unable to undergo a knee replacement surgery that had been scheduled for the end of March. So the plaintiffs were multiple healthcare providers and a patient, and they were prohibited from performing or receiving non-essential medical procedures by the orders of Michigan Governor Gretchen Whitmer. Now, they sued in the district court for the Western District of Michigan, Southern Division. As part of that case, the district court certified 2 questions that needed to be answered by the state's Supreme Court. The questions dealt with whether or not Governor Whitmer had the authority to issue COVID-19 related executive orders under 2 Michigan laws, the Emergency Powers of the Governor Act, or EPGA, and the Emergency Management Act, otherwise known as EMA. Now, you may be asking yourself, why does Michigan have 2 different emergency powers laws? Well, I'm not an expert on Michigan law. It does appear that the EPGA, which was passed in 1945, did not include a time limit on the declaration of emergency, while the EMA, which was passed in 1976, does. This will become important as we dig further into this case. Now, back to the syllabus. Whether under the Emergency Powers of the Governor Act or the Emergency Management Act, Governor Whitmer has the authority after April 30th, 2020 to issue or renew any executive orders related to the COVID-19 pandemic. The first of the two questions the district court had for the Michigan Supreme Court had to do with whether the EPGA or EMA delegated to Governor Whitmer the authority to issue or renew executive orders related to the COVID-19 after April 30th. That date is important, as we'll see soon. See, Michigan law does delegate to the governor the authority to declare an emergency or disaster, which grants the governor emergency powers. However, that power comes with limitations. The EMA states, the governor shall, by executive order or proclamation, declare a state of disaster if he or she finds a disaster has occurred or the threat of a disaster exists. The state of disaster shall continue until the governor finds that the threat or danger has passed, the disaster has been dealt with to the extent that the disaster conditions no longer exist, or until the declared state of the disaster has been in effect for 28 days. After 28 days, the governor shall issue an executive order or proclamation declaring the state of disaster terminated unless a request by the governor for an extension of the state of disaster for a specific number of days is approved by resolution of both houses of the legislature. So under the EMA, once the governor issues the executive order declaring an emergency or disaster, it is in effect for 4 weeks, unless the legislature issues an extension. Now, what does the governor do if they want to continue the emergency, but the legislature doesn't grant the extension? On April 30th, 2020, the governor issued EO 2020-66, which terminated the declaration of a state of emergency and state of disaster under the EMA. But immediately thereafter, she issued EO 2020-67, which indicated that a state of emergency remained declared under the EPGA. At the same time, she issued EO 2020-68, which redeclared a state of emergency and a state of disaster under the EMA. Although EO 2020-17 has been rescinded, the federal district court held that the case is not moot because the subsequent executive orders have continued to impose restrictions on healthcare providers. Now, this shell game has been tried before. In the case New York State Rifle and Pistol Association versus New York City, the city claimed the plaintiff had no standing because, well, part of the law had been rescinded. Here, the state of Michigan claimed that since the states of emergency and disaster orders had been terminated, the case was moot. However, the district court noted that the order that had terminated the states of emergency and disaster had immediately been followed by new declarations of a state of emergency and disaster in an attempt to restart the clock. But there's a twist. See, while Governor Whitmer rescinded her order under EMA, she claimed the power to issue the new emergency and disaster declarations under EPGA. Why? Because EPGA does not include a time limit on her declaration. Now, this was a blatant attempt by the governor to get around the fact that the state legislature refused to further extend the governor's declaration of a state of emergency and disaster, as required by Michigan law. Thankfully, both the district court and the Supreme Court of Michigan saw through this subterfuge. First, under the EMA, the governor only possessed the authority or obligation to declare a state of emergency or a state of disaster once, and then had to terminate that declaration when the legislature did not authorize an extension. The governor possessed no authority to redeclare the same state of emergency or state of disaster and thereby avoid the legislature's limitation on her authority. So the justices on the Supreme Court of Michigan slapped Ms. Whitmer on the wrist for trying to get around the statutory limitations on her power, though that was only one of the questions this court was asked to respond to. To me, the more important question dealt not with the extension of the emergency powers, but whether the legislation delegating to the governor the power was valid in the first place. This was the second question the district court sent to the Supreme Court of Michigan. Whether the Emergency Powers of the Governor Act and or the Emergency Management Act violates the separation of powers and or the non-delegation clause of the Michigan Constitution. An important protection of the rights of the citizens in this country is the separation of powers. The idea is that no one person or group can be trusted to exercise all or even most of the powers of government. Now, in the United States of America, along with all of the several states, these powers are divided into three groups: legislative, executive, and judicial. We were all taught in school, or at least we should have been, that these checks and balances are crucial to a just government. Michigan, along with many other states, expressly prohibit the delegation of powers from one branch to another. Quote, "The powers of government are divided into three branches: legislative, executive, and judicial. No person exercising powers of one branch shall exercise powers properly belonging to another branch, except as expressly provided in this Constitution." So the question before this court was, did one of these two Emergency Powers Acts violate this section of the Constitution of Michigan? Apparently, all of the judges but one agreed that it did. Quoting, Justice Markman, joined by Justices Zara and Clement, concluded that the governor lacked the authority to declare a state of emergency or a state of disaster under the EMA after April 30th, 2020, on the basis of the COVID-19 pandemic, and that the EPGA violated the Michigan Constitution because it delegated to the executive branch the legislative powers of the state government and allowed the executive branch to exercise those powers indefinitely. Now, while other justices agreed with that part of the decision, there was one dissenter, a Justice Bernstein. Justice Bernstein concluded in part and dissented in part, disagreed with the majority's conclusion that the EPGA is unconstitutional. An examination of case law from both the Michigan Supreme Court and the United States Supreme Court supported the conclusion that, under current law, the grant of power in the EPGA does not offend the separation of powers. Now, I'm not going to take the time to get into the case law and constitutional law, but if we look, the EPGA does state that in times of public emergency, the governor can proclaim a state of emergency. The law then goes on to say, quote, "After making the proclamation or declaration, the governor may promulgate reasonable orders, rules, and regulations as he or she considered necessary to protect the life and property or to bring the emergency situation within the affected area under control." Now, according to the court, the effective lawmaking authority the governor possesses during a state of emergency is only constitutional if it is allowed for a limited period of time. With both the EPGA and the EMA, the Michigan legislature effectively delegated some of its lawmaking powers to the governor during a state of emergency. Since the 1945 EPGA allows the governor to indefinitely assume some legislative powers after declaring an emergency, it violates the state's non-delegation clause. Now, for those of you who have been living under Governor Whitmer's tyrannical executive orders, this is a victory. But if you rest on your laurels, it will be a short-lived one. Remember the words of Alexander Hamilton. The judiciary, on the contrary, has no influence over either the sword or the purse, no direction either of the strength or of the wealth of society, and can take no active resolution whatever. It may truly be said to have neither force nor will, but merely judgment, and must ultimately depend upon the aid of the executive arm, even for the efficacy of its judgments. The courts have no power to force their opinion to be followed. In fact, the Supreme Court of Michigan is dependent on the very executive they just rebuked to enact their judgment. Now, thankfully, the people of the state of Michigan have no such restrictions. The executive orders, EO 2020-67 and 68, declaring states of emergency and disaster after April 30th, are void. Again, the words of Mr. Hamilton from Federalist Papers number 78. There is no position which depends on clearer principles than that every act of a delegated authority, contrary to the tenor of the commission under which it is exercised, is void. As a government official, Governor Whitmer is exercising delegated authority under her commission as governor of the state of Michigan. Therefore, any of her acts contrary to her commission, which includes supporting the constitutions of both the state of Michigan and the United States, well, they're void. While it's the obligation of the governor to rescind these two orders, it is the duty of the people of the state of Michigan, both inside the government and out, to ignore them. If they do not, then Michigan is no longer a state of laws, no longer run by a government of the people, by the people, and for the people. No, if the people will not uphold the supreme law of their state, then Michigan no longer has a Republican form of government. Rather, it has become a monarchy, where the people are ruled by the governor in Lansing, instead of the other way around. Now, for those of us who do not live in Michigan, this should be a clarion call. We should all check our state constitutions for similar non-delegation clauses and see if our state's emergency powers laws violate such a clause. Let's make sure that the powers we have delegated to our state governments are being exercised within the commission we've given them in the constitutions that created them. And if our laws and or constitutions need to be fixed to protect us from similar government overreach, then we should start working on that task with those we hire to represent us. Since there is an election coming up, I can think of no better question to ask a candidate after they show how they've supported the Constitution of your state and of the United States than how they plan to work towards fixing this problem. So, good news out of Michigan. We have a Supreme Court of the state which has read their Constitution and read the laws and said, no, Governor Whitmer, your power is limited, and that's the opinion we found. Now, yes, one justice went through and said, no, she can do whatever she wants because of previous courts, but let's take the win. But let's not spike the football. Let's not take the fact that we got a first down and assume we've won the game. We need to keep pressing, whether that's the people of the state of Michigan ignoring these executive orders and holding their elected and appointed officials accountable to ignore orders that are void, whether it's the people in the other states that learn from this and say, let me look at my state constitution, let me look at the laws of my state and see if they work. Let's use this as a rallying cry, not simply to spike the football and go home, but to move forward, to line up for the next down, to get ready for the next battle, because it's coming. I pretty much can guarantee it. Let's enjoy the win, but let's prepare for the next down. And if you enjoyed this, I hope you'll consider supporting the work that we're doing here. The Constitution Study Podcast exists because the people support the work that I'm doing. They find these podcasts useful, they like the videos, they like the articles, and they want to see more. And if you want to see more of these, please head over to the website, constitutionstudy.com, and consider donating. Everything you donate through the website goes towards supporting this podcast. I don't take a dime from it. It keeps this podcast going. It keeps this podcast free. It means I don't need to go out and find sponsors and put advertising in here. It's everything I'm trying to do to keep this as a free flow of information for you. Now, if you want to support me in the work that I'm doing, if you want to help me put on these webinars, go to these events, speak to different groups, to be able to do so without charging them. That's probably the biggest hindrance right now to me going out to events is if they're not in my immediate area, somebody has to pay for my travel. So if you want me to be able to go and share these events, then consider buying a book or two, signing up for a membership, becoming part of the process. The books are great, and I'd love for you to go to the store, constitutionstudy.com/shop, find a book, share a book. I love it. But if you really want to see this keep going, consider a membership. Right now, the Constitution Scholar membership, there's one level. It's $5 a month or $50 a year. That goes towards keeping me going and keeping me able to share this with others. Whether I'm going to shows or conferences where I can spread the word, or whether I'm going to meet people and talk to them, even to help them with questions. I've been getting questions from people about suits they're considering or laws they're acting on. Help me help them. Help spread the word of liberty. You can do that through, again, a membership or just buying something on the Constitution Study store. If nothing else, like I said, sign up for the newsletter. It's a great way to get the information, but please share these videos. Well, yes, I need money to keep this going. I think sharing these videos are the most important thing. Sharing the articles, sharing the news, because I met someone new this week, and As usual, we were talking about what we do for a living. I got started, and it didn't take but about 30 seconds for his eyes to open up as I'm like, really? I didn't know that. I hadn't been taught that. So let's help spread that word. Let's help people realize the way this country is supposed to run. And hopefully you've found value in what I've brought you. Hope you've found it worth it enough to either donate to the podcast, to consider a membership, or just buying a book. But most of all, I hope you found it valuable enough you'll come back next time for the Constitution Study.
There's one thing you have to know wherever you make your stand.